Hi everyone. Today we discuss about 1956 Constitution. At first, we know the contents of this topic. These are introduction, features of the 1956 Constitution. Fundamental rights, directive principles of state policy, parliamentary forms of government, the president and government, the federal government, provincial government and legislature, distributions of powers between the centre and the provincial, Islamic provisions and conclusion. Let's start. Now we know about the 1956 Constitution introduction. A constitution is primarily a set of rules and principles specifying how a country should be governed, how power is distributed and controlled, and what rights citizens possess. Ways in which a constitution can be amended. A constitution must contain a clear statement of the processes by which it can be changed. On the basis of biracialism, Pakistan gained the status of an independent state on the 14th of August 1947. After 9 long years of efforts, the first constitution of Pakistan was drafted in 1956. Known as the 1956 Constitution or Constitution. In its general aspect, the 1956 Constitution was based on the pattern of the Government of India Act 1935. However, it was abolished by the imposition of martial law on the 6th of October 1956. The 1956 Constitution was lengthy and detailed. It contained 234 articles, divided into 13 parts and 6 schedules. On examination, we find several explanations for its length as stated below. 1. The Islamic character of the Constitution sought to base the Constitution on Islamic principles and provisions which occupied some length. 2. It was a federal constitution which is usually more complex, prescribing not only for the federation but also for the units. 3. The relations between the federation and the provinces were complicated, necessitating in special areas. 4. Some provisions had to be made for tribal areas and special areas. 5. Some matters which could have been dealt with by ordinary legislation, such as judicial organization, were included in the Constitution. The organization of the federal court and the judiciary of the provinces occupied as many as 31 articles. 6. There were other matters which the Constituent Assembly thought fit to include in the Constitution, relating to the public services, the languages of the Federation, and the Election Commission, and others. 7. It was found necessary to include emergency provisions covering Part 9 of the Constitution, and 8. Lastly, it was thought fit to include not only a lengthy Bill of Rights but also direct the members of the National Assembly and provincial assemblies, as well as the provincial governors. The 5th with the lists of subjects for which either the Federation or the provinces, or both concurrently, would be competent or legislate. And the 6th with the election of the first President of the Republic, principles of state policy. Now we know 1956 Constitutional features. Features of the 1956 Constitution of Pakistan. The Constitution of Pakistan of 1956 was full of several features. They are discussed below. Greater Constitution. The 1956 Constitution was one of the largest in the world. The 105-page Constitution had 1 preamble, 13 parts, 234 rules and 7 lists in written form. Islamic Constitution. As a symbol of the hopes and aspirations of the vast majority of Muslims in Pakistan, the 1956 Constitution called Pakistan an Islamic Republic and stated that it could not enact laws contrary to the Quran and Hadith. You can read more. Discuss the reasons for the failure of the initiative to form a united independent Bengali state. Introduction of democratic system of governance. The Constitution of 1956 introduced representative democratic system of government in the country. Provision is made for the election of members of the Central provincial legislative assemblies and other elected bodies by universal suffrage. Republican Constitution. In the 1956 Constitution, Pakistan was called a republic. In this constitution, the head of state became known as the president. He was mentioned to be elected by the members of the legislature. Federalism. The 1956 Constitution introduced federalism in East and West Pakistan. Provincial system of government. In the Constitution of 1956, autonomy system was adopted in the provinces. Provincial governments were accountable to the provincial legislature for their actions. However, it has come to a standstill due to various provisions of the Constitution. Introduction of cabinet-ruled government. The 1956 Constitution introduced a system of cabinet-ruled government in the centre and province similar to the British Constitution. It is mentioned that the cabinet will be accountable to the legislature. Inflexible. This constitution was inflexible or changeable. For this reason, a 2/3 vote was required to change, amend the Constitution. One-chamber legislative assembly. In the 1956 Constitution, a one-chamber legislature was formed to solve economic and many other problems. Dominance of the judiciary. This constitution recognizes the independence and supremacy of the judiciary. Because the judiciary is a significant bulwark against individual freedom, one-centered tendency was kept in the 1956 Constitution. The central government could interfere in the power of the provincial government if necessary to maintain state peace and order. Universal suffrage. The 1956 Constitution adopted the principle of universal suffrage for all adults irrespective of caste, creed and creed. Provisional provisions. A number of provisional provisions were inserted in the 1956 Constitution to make the constitution of the state in accordance with the Constitution. Although they did not have legal status, they were adopted as the norm for governing. Strong center. The center was established as very strong in the 1956 Constitution. The power of the center to intervene was vested in some provinces. After 9 years of tireless work, the Second Constituent Assembly of Pakistan drafted a constitution in 1956 which came into force on March 23, 1956 and lasted till October 7, 1956. Only 2.5 years later, it was abolished by the military. Yet it played an important role as the first constitution of Pakistan. Fundamental rights. All citizens were equal before the law and entitled to equal protection of the law. 2. No person could be deprived of life or liberty, save in accordance with the law. No person could be punished for an act which was not punishable when committed. The right to apply for a writ of habeas corpus could not be suspended, except in the case of an external or internal threat to the security of the state or other grave emergency. There should be no discrimination on grounds of religion, race, caste, sex or place of birth with regard to access to places of public entertainment, recreation, welfare or utility. The notion of untouchability being inconsistent with human dignity, its practice was declared unlawful. These fundamental rights contained a clear statement regarding the rights of individuals, and these rights were fundamental not only in the sense that they had been mentioned in and guaranteed by the Constitution, but were such as neither the legislature nor the executive could in any manner curtail or diminish. Now we know about something details. Directive Principles of State Policy. The Basic Principles Committee had recommended the inclusion of Directive Principles of State Policy. The following were included in the 1956 Constitution. 1. Steps should be taken to enable Muslims to order their lives in accordance with the Quran and Sunnah and to Aliyah. 2. Provision of food, clothing, housing, education and medical relief should be made for citizens incapable of earning their livelihood owing to unemployment, sickness, or similar reasons. 3. The improvement of living standards, the prevention of the concentration of wealth and means of production in the hands of a few, and the prevention of the exploitation of the workers and peasants. 4. Abolition of illiteracy as rapidly as possible. 5. Training and education for the population of different areas to enable them to participate fully in all forms of national activity and service. 6. Discouragement of parochial, tribal and racial feelings among Muslims. 7. Promotion of peace and goodwill among the peoples of the world. 8. Separation of the judiciary from the executive as soon as practicable. 9. Protection of all legitimate rights and interests of non-Muslim communities. 10. To achieve parity in the representation of East Pakistan and West Pakistan in all spheres of federal administration. Parliamentary form of government. The first Constituent Assembly decided in favour of the parliamentary form of government, both at the centre and in the provinces. There were some who believed that parliamentary democracy was not suited to Pakistan. Their main contention was that a new country like Pakistan required more than anything else a stable and strong government. We find that the Draft 8 presented to the present Constituent Assembly in January 1956 had to be modified considerably regarding provisions relating to the powers and position of the head of the state. A parliamentary system was sought where real executive authority vested in a cabinet responsible to the legislature would be guaranteed in the constitution and not, as in Britain and in some Commonwealth countries, based on conventions alone. In most important matters he acts on the advice of the cabinet. The President and the Cabinet. The executive authority of the Federation 1956 Constitution was vested in the President and was to be exercised by him in accordance with that Constitution. The President was to be a Muslim of not less than 40 years of age and qualified for election as a member of the National Assembly. He was to be elected by an electoral college comprising members of the National Assembly and the provincial President was away from Pakistan or unable to perform his duties. The Speaker of the National Assembly would exercise the functions till the President resumed his duties or until a new President were elected. The Constitutional provided for a cabinet of ministers with the Prime Minister at its head to aid and advise the President in the exercise of his functions. The President was required by the Constitution to act in accordance with the advice of the Cabinet, except in those letters in which he was empowered to act at his discretion. It was the duty of the Prime Minister to communicate to the President all decisions of the Cabinet and proposals for legislation and to furnish him with information as the President might call for. The Prime Minister shall hold office during the pleasure of the President. Such was the proposal in the Provisional and Draft Constitution presented to the Second Constituent Assembly in January 1956. But the proposal evoked great criticism and fears were expressed that his might lead to repetition of the Cabinet dismissal of 1953. Functions and powers of the President. The President, on the advice of the Cabinet, was entrusted with multifarious functions. Some of the key appointments, such as those of the Chief Justice of the Supreme Court and judges of the 9 Supreme and High Court, the governors of the provinces, the Attorney General, and the principal military officers, were made by the President on the advice of the Cabinet. He also had the power to issue proclamations of political or financial emergency and could suspend a provincial government. The administration of the federal capital was vested in the President. He was also given powers to grant pardon and to remit, suspend or commute a sentence passed by any tribunal. Similarly, the President was given certain legislative functions to be exercised on the advice of the Cabinet. He could also send a bill for reconsideration, and if such a bill were passed again by a majority of the total members of the Assembly, it had to receive his assent. When the National Assembly was not in session, the President possessed the positive power of making laws by ordinances which were to be laid before the National Assembly and would cease to operate at the expiry of 6 weeks from the next meeting. of the National Assembly or at such time as a resolution of disapproval should be passed by the Assembly. The federal government. Another basic feature was the federal form of the Constitution, following the decision in 1949. Although the solitary voice of the independent member, Fazlur Rahman, could be heard in the Second Constituent Assembly in favor of a unitary form of government, the 1956 Constitution embodied all the characteristics of a federation, a written constitution, dual polity, distribution of powers between the national and provincial governments, and a Supreme Court. The process of decentralization, therefore, was allowed under the 1956 Constitution to an extent which was unusual with other new federal constitutions. The federal government was fully equipped for the conduct of international affairs. Parliament was authorized to implement treaties with laws which it might have no power otherwise to pass. A treaty could reach and control matters normally within the powers of the provinces. There was no provision in the Constitution, as under the Indian Constitution, whereby the federal legislature could make laws in any provincial matters on the grounds of national interest. There were, however, at least two processes which would enable the federal legislature to legislate even on a provincial subject. Provincial governments and legislatures. The provincial legislatures and executives were small replicas of the national legislature. Provincial assemblies, like the National Assembly, were unicameral and were to be directly elected by the people through universal adult franchise under the same electoral law. The relationship between the provincial governor, provincial chief minister and the provincial assembly closely resembled that between the president, the prime minister and the National Assembly. The governor could appoint and dismisses the provincial cabinet through a procedure similar to that of the president in exercising his power at the center. The provincial cabinet was also collectively responsible to the provincial legislature, which could be dissolved by the governor on the advice of his cabinet. Distribution of powers between the center and the provincial. In 3. Distribution of legislative powers between the center and the provinces. The framers of the 1956 Constitution allowed a greater decentralization than under the Government of India Act. 1935. Administrative relations between the center and the provinces, however, changed a little. The federal system showed a marked tendency towards unified control and authority. The central government would make laws in the federal or concurrent lists which would apply to the province's disturbance. The federal government was entitled to give direction to a province with regard to the duties of the provincial authority and was further entitled to give directions to a province in the following matters. 1. The construction and maintenance of the communications declared to be of national or military importance. 2. The measures to be taken for the protection of railways within the province, although railways were included under the provincial list. 3. The manner in which the executive authority of the province was to be exercised for the purpose of preventing any grave menace to the peace and tranquility or economic life of Pakistan or any part thereof. 4. The carrying into execution in the provinces of any Act of Parliament in Part 2 of the concurrent list, such as measures to combat corruption, or price control and economic or social planning. Islamic provisions. According to the Constitution, Pakistan was declared as an Islamic republic wherein the principles of freedom, equality, tolerance and social justice at any enunciated by Islam should be fully observed. According to the Constitution, Pakistan was declared as an Islamic republic wherein the principles of freedom, equality, tolerance and social justice at any enunciated by Islam should be fully observed. The original proposal provided for a vice president who should also be a Muslim, but the provision was not accepted. The Speaker of the National Assembly would exercise the functions of the President if he was absent from Pakistan or was unable to discharge the duties of his office owing to illness or any other cause. The Speaker might be a non-Muslim, so occasion might arise when the temporary head of the state could be a non-Muslim. Finally, we discuss about 1956 Constitution in conclusion. The type of emergency for which the 1956 Constitution made provisions related to the financial stability or credit of Pakistan. The salient features of the 1956 Constitution, along with their historical perspective, have been discussed above. Other features included the composition of the Election Commission of Pakistan for holding periodic elections to the National Assembly and the provinces' assemblies. Determination of conditions of service of persons in the service of Pakistan, formation of all Pakistan services, and establishment and composition of public service commissions. Urdu and Bengali were declared as the state languages. Pakistan's first Constituent Assembly had still not completed its task of constitution making when in October 1954 it was abruptly dissolved by the Governor-General, Ghulam Muhammad. After much legal uncertainty, he summoned a new Constituent Assembly, which in January 1956 presented a draft constitution, which with certain changes was adopted on the 29th of February and came into force on the 23rd of March. It described Pakistan as an Islamic republic and in the only clause that discriminated between citizens on grounds of religion, provided that the head of state should be a Muslim. The Second Constituent Assembly, like its predecessor, was elected indirectly by members of the provincial legislatures. Its class composition turned out to be much the same, namely the majority of its members were educated and well-to-do men and women whose views on the place Islam should occupy in 14 public affairs differed radically, as time was to show, from those of the vast unlettered mass of their fellow countrymen. Thanks for watching this video. Please subscribe our channel, Arman Education Center. As soon as possible we will upload next video. Stay with us. Thank you.